So good afternoon. I'm thrilled to be having a short conversation today with Professor Michael Lynk. Michael Lynk is, of course, the former rapporteur on human rights in the occupied Palestinian territories. He has had a great deal of international law experience, and I wanted to quiz him today a bit on this submission that Canada made to the International Court of Justice regarding a UN resolution asking the court to look at Israel-Palestine. Michael, thank you very much for spending some time with us today.
My great pleasure, Peter.
Michael, um, the Canadian, as I understand, correct me if I'm wrong, this resolution came to the United Nations back in December. It was adopted quite handily, although there were quite a few abstentions as well.
Mm-hmm.
And the recommendation went to the International Court of Justice to examine Israeli practices in a couple of areas that were specified. At that time, Canada voted against this. Canada was one of the countries who voted against it, and that would mean Ambassador Bob Rae would have voted against it on behalf of Canada. The main argument then was that what was the main argument that we offered at that point?
Well, let me just give a background to everybody so they understand the context of this.
Sure.
In 2003, the General Assembly of the United Nations adopted a request for an advisory opinion that went to the International Court of Justice, asking it to rule on the legality of the wall that Israel was then building through the West Bank. There were objections raised at that time saying that the court shouldn't accept jurisdiction over this because Israel did not consent to give its jurisdiction. Indeed, that was one of the arguments made by Israel on the basis of jurisdiction. The court declined to decline its jurisdiction, if you like, and went on to make a substantively influential decision that the wall that Israel was building was illegal because it was being built in the West Bank in occupied territory. It went on to say that the Israeli settlements that were then being built in the occupied Palestinian territory were illegal under international law, and it worried that the wall where it was placed, 85% of which was in the occupied territory, may amount to de facto annexation. So it ordered Israel to stop building the wall and also ordered Israel to pay reparations. Neither of those two recommendations were accepted by Israel. The wall kept on being built.
They just ignored it, basically.
So in the summer and fall of 2022, the Palestinians then decided to raise again ask the General Assembly to vote on a new advisory opinion going to the International Court of Justice in The Hague. This time asking much more substantial questions, going to, what are legal consequences going to Israel's denial of the right of Palestinians to self-determination? What are the legal consequences with respect to having a prolonged 56-year-old occupation, the settlements, the annexation of Palestinian territory, the change in the demography of East Jerusalem and the occupied territories, and related discriminatory legislation and measures. And then what are the legal consequences for Israel, for the United Nations, and for all states? So what's happened since then is that the request from the General Assembly has gone to the International Court of Justice. There was a general statement issued in March or so by the ICJ asking for any interested state or recognized international institution to file their written statements by July 25th. And I think there were 57 written statements issued altogether. I think there were 11 or 12 that, like Canada, said to the court, you should not accept jurisdiction, you should turn this down, don't answer the questions on its merits. Almost all of the rest of them did say, that the court should accept jurisdiction, it should answer the questions that have been substantively asked to it, and they should rule on what the legal consequences are. The court hearings will be held sometime next spring or summer, and you'll probably have to wait 6 to 8 to 10 months after that for a decision sometime late in 2024. So that's the background to all this. As I said, there are probably about 10 or 11 countries that file statements which said court don't accept jurisdiction. Canada was one of them.
No, excuse me, Michael. Canada could have not made a submission, right? I mean, there's no obligation to make a submission. Canada chose to raise its hand and say, we want to protect Israel by having the court not look at this issue. Is that right?
That's in effect, I think, what's happened politically with respect to I think Canada is doing a favor to Israel. It's certainly Israel's position that the court should not accept jurisdiction. And Canada has in fact echoed that. The written statement by Canada, I believe, is about 6 pages long. The United States has made the same argument, only on jurisdiction, with the same conclusion: court, you shouldn't accept jurisdiction. But their submission was 108 pages long. As a lawyer, I would look at this and say, I've come across enough situations in my legal career to know when a lawyer doesn't have the heart in the case that they're arguing on behalf of their client. And I got a sense that given how shallow the arguments are that Canada has raised in its written statement, that it didn't have its heart in this either. But you're perfectly right, Peter. It could have taken the position that we weren't going to say anything. And indeed, there are 2 notable countries in Europe, the Netherlands and Germany, for example, who have strong relationships with Israel, that declined to submit any written statement to the International Court of Justice. And that I suspect has to do with the disfavor that those 2 governments have with the current government in Israel. Canada could have done the same, but it didn't. It decided to intervene on the side of Israel and simply say everything should be subject to negotiations.
Right.
And that the Palestine doesn't really have a right to go to the court and ask for a legal determination on these questions.
Okay, so Canada chose to intervene. We use these arguments that seem questionable at the very least. I mean, to say that Israel has to agree before you can. Even if our arguments had been strong, we wouldn't have very much influence from the court. So we're not actually expecting to block this. The court has got 50 some submissions. Canada's arguing. So Canada is not doing this really to try to block this. Canada is making some kind of political statement about whose side we're on, or why are we bothering?
Well, that's a good question, because I don't believe in the history of the International Court of Justice that it has ever declined to give a substantive answer when the United Nations Security Council or the United Nations General Assembly has asked it to give an advisory opinion on a question. It's never declined to do that. So Canada can't point to any precedent where the court has done that before. So I can only believe that it probably has to do with internal politics, Canadian politics. One would think that that decision making in global affairs and in the Prime Minister's office with respect to Israel and Palestine is very much reflective of where it sees the balance of power in Canadian politics with respect to this. And I suspect then that the lobby that acts on behalf of Israel has strongly pushed Canada to intervene on the side of Israel to ask the court to decline jurisdiction.
That seems logical to me. I say it must be just trying to demonstrate to its Israel supporters in Canada that Canada's on your side, even though we know this is the arguments are weak and we're not actually going to make any have any effect. Michael,
take a look, Pete. Sorry, just take a look at the two arguments that have been raised by Canada. Number one is, court, you shouldn't hear this because we think everything has to be done through direct negotiations between the Palestinians and Israel, when it's very clear to anybody who pays attention to what's going on in the Middle East that Israel opposes a two-state solution that Canada says it winds up supporting. The prior Prime Minister of Israel, Naftali Bennett, said almost 2 years ago in September 2021, he said, "I oppose a Palestinian state, and I'm making it impossible to conduct diplomatic negotiations that might lead to a Palestinian state." The current Prime Minister, Benjamin Netanyahu, has signed an agreement with his coalition party partners, which says that only Israeli Jews have the right to self-determination in the land of Israel. The land of Israel being the original Mandate Palestine between the Mediterranean and the Jordan River. He too absolutely opposes the creation of a Palestinian state. So for Canada to say we believe in a Palestinian state and it can only be achieved through negotiations, when of the two parties, only one of them, the Palestinians, support a Palestinian state, it seems exceptionally odd to be able to justify Canada's position. The second position it's taken is that this is really a matter of jurisdiction from the UN Security Council, not for the General Assembly, which again is an odd position to wind up taking, given that it was the UN General Assembly in 1947 that passed the partition resolution that Israel regards as its birth certificate, which was actually included in its 1948 Declaration of Independence. And it's the United Nations General Assembly which has said repeatedly that the United Nations has a permanent responsibility to resolve the question of Palestine satisfactorily in all of its aspects. I've not heard of this argument before, that the question of Palestine is a matter only for the Security Council and not for the General Assembly or other organs of the United Nations more generally.
And I can't imagine that even had it been preferably made from the Security Council, that Canada would have said, "Okay, well, that's okay, we'll go for it." It seems to me
that would be surprising. Mind you, the reason why they would point to the Security Council is that Israel, if you like, has a direct line to the United States veto on any resolutions that are critical of Israel. Keep in mind that in the last 14 and a half years, since February of 2009, the United Nations Security Council has only ever passed one resolution critical of Israel. That was done in December 2016 at the very end of the Obama administration.
So as I understand it, that was 2334. As I understand it, that resolution was should have been followed by every UN nation, and Canada has ignored it. One of the things was that it called for differentiation in the treatment of goods and people from the occupied territories, and Canada has so far ignored that.
And that I'm afraid is the case. It calls for a differentiation between Israel and the occupied territories, which would mean not accepting goods and services coming from the settlements into the Canadian economy. We not only allow them to come in, we allow them to come in tariff-free through the Canada-Israel Free Trade Agreement, right. which I think is a violation then of both Canadian and international law.
Michael, I think this has been very helpful. I think many people will be disappointed that Canada feels once again an obligation to stand up and defend Israel, even at a time when the current Israeli government, I think most Canadians would find is quite problematic. But that doesn't seem to stop our government from supporting an Israel right or wrong kind of policy. Michael Lynk, thank you very much for spending a few minutes today explaining the situation, and we'll see what happens when that resolution goes. It will be adjudicated by the court. When is it?
Probably in the late winter, early spring of 2024.
Well, we'll see. We'll come back and revisit it then after that time. Thanks again, Michael.
I'd be happy to do that, Peter.
Yeah.
Thank you very much.
Have a good day.
You too.
Bye-bye.